Your Honor, for the record, Ms. Fowler is also guardian ad litem.
Thank you.
Department calls Terry Greenroy, and you have been their caregiver full time, for lack of a better word, for about how long?
About 3 years.
Would it be fair to say that though legally you may not be their parent, you have been their parent, in fact?
That's correct.
And how are the kiddos doing?
How are the what?
How they doing? Kiddos doing.
Children just doing exceptional. The little girl is a straight A honor student. Little boy is a AB honor student. Well adjusted, personality wise, emotionally, very strong and stable and secure. And
do I remember from a previous hearing that Kaysen, who is the girl, is into everything, including FFA raising bunnies?
That's correct. She's an officer in FFA at this point, but she's involved into tennis, basketball, volleyball, FFA, you name it. She's on the go all the time, which includes me. I'm on the go with her.
And I do have to ask, how did the bunnies do at competition?
How did the bunny do at competition?
The bunny? Oh, the bunny got awarded some prize money. But I can tell you that she loved the little bunny at first, but the longer it went, and she realized the amount of care that goes into taking care of this bunny got a little bit overwhelming for her.
Now you understand why we're here today, is that correct?
What?
You understand why we're here today?
Yes.
Okay. That if the judge goes along with what the department is asking, you will be named managing conservator, which is the legal equivalent of being the parent. You understand that, right?
Yes.
And that the department gets out. You understand that?
Yes.
As I understand from what I've read, you don't need anything else from CPS, right?
That's correct.
But you have done your negotiations with it's called the PCA, permanency care assistance people, so that once we get out, you will be getting some financial help to raise 2 very active grandkids.
Yes.
I understand that you saw your daughter, Autumn, at a track meet relatively recently.
That's correct.
It was not scheduled as a visit. Is that correct?
That is correct.
However, those things are public, aren't they?
Yes.
I also understand that in order to not cause a scene, you didn't yell and scream and demand she leave Kaysen alone. Is that right?
That's correct. I would not create a situation like that in front of the child under any circumstances. I don't know that I would, even if it had just been her and I. You know, I'm pretty logical, self-controlled. I wouldn't launch that kind of an attack.
I also understand you believe that your daughter is once again using drugs. Is that right?
It's clear without question to me. When the last time I saw her at the track meet there, she looked horrendous. She probably lost 60 or 70 pounds. She's lost some teeth. She looked really bad. I'm really concerned about her health now.
And prior to that meeting, that chance meeting in public, had she called you at least once and sort of chewed you out and cussed you out type thing?
You know, she showed up in at my house one night about 7 p.m. out of the clear blue sky, and she proceeded to tell me that she was sick of CPS and everybody involved in it. She didn't like the meeting she'd had with Danielle at one point. I think the meetings were going good, and obviously something was said she didn't like, and so she just walked out on Danielle. And she just told me she did not want to be involved with CPS. They lied to her, misled her, da-da-da-da-da-da. And I said, you know what? You only had 1 meeting with CPS or 2 at the most. And I said, I've been dealing with CPS for 3 years. So don't preach to me what CPS is or what they do. I know what they do. And she stormed out of the house at that point.
And is it your understanding Mr. Latham is in prison?
That's correct.
Now, do you agree with me that appointing either Autumn or Mr. Latham as managing conservators would not be in the children's best interest because it would impair their physical or emotional well-being?
Absolutely. I totally agree.
And do you agree with me that appointing you as managing conservator would be in their best interest?
Absolutely, yes.
You're over the age of 30. So do you think you can handle having grandkids up until, you know, they move back in after college?
You know, I question it on a daily basis when I'm running here, gone, or never with a kid, but no, I can handle it.
Do you have any questions about what the department is asking for with you named managing conservator?
I do not.
Okay. Now, Ms. Fowler sent us an email this morning. I want to talk to you about visitation and things like that. Now, the parents are going to be named temporary possessory conservator, which is what they are now, and they have certain rights. And I want to know if you're going to ask the court to limit those rights. They have the right to get information from you about the health, education, and welfare of the children. You think they should have that right? If they call and ask you, you can tell them?
Is that a question to me or?
Yeah.
That's to you.
Yes, yes.
Okay. However, they also want, the law says that they would have the right to talk to you about any decision regarding their health, education, and welfare. Do you think
Yes.
they should be able to do that, or do you think the judge should limit that?
You know, I think to an extent it should be limited. I think that decision should lie solely with me. I don't have any problem if the parents have a question about our direction, you know, and explain to them why we're doing such.
But the very short reason on Autumn is she's not been involved really for 3 years, right?
That's correct.
The other one is accessing medical, dental, psychological, and educational records of the children. Do you agree with me that they should not have that right?
Yes.
Okay. Are you also asking that they not have the right to consult with physicians, dentists, or psychologists of Kaysen and Terry?
I agree, yes.
Do you believe they should not have the right to consult with school officials regarding your children's welfare? I'm sorry, I'm calling them your children, but you know who I mean, right?
Yes.
Welfare, educational status, and school activities. They shouldn't have that right, should they?
I agree.
They should not have the right to attend school activities and school, including school lunches, performances, and field trips. You can't keep them away from public events, but they don't have the right to show up at school for the, you know, senior night when they give the parents roses and stuff like that.
Right. Yes, I agree with that.
Okay. Do you agree they should not be designated on Kaysen and Terry's records as a person to be notified in case of an emergency?
I agree with that.
Would you agree with me? One of the worst things that could happen is if they called Autumn Greenroy, if they couldn't get a hold of you and she shows up and takes the kids.
Yes.
Do you agree that they should not have the right to manage the estate of the children? I know the kids aren't rich, but you know, I don't know, maybe Kaysen sells the bunnies for, you know, $100,000. They shouldn't have that right. Does that sound fair?
That's correct. Yes.
Okay. However, do you believe that they should have the right to consent to medical, dental, and surgical in an emergency if you're not available?
That the parents should have that right?
I'm asking you that, yeah.
You don't have alternate people that I would place in that position before I would do.
Okay, so you don't want them to have that right either?
No.
Okie dokie. Regarding visitation, are you asking for the same visitation that we currently have under the order that's in place now, which is that Autumn gets visits only after she tests negative on a hair test and only after any therapist for Kaysen and Terry recommend it and you supervise them?
Correct. Yes.
And that Mr. Latham, as long as he's in jail or prison, continues to get 2 phone calls supervised by you a month. And when he gets out, he gets visitation that you agreed to, supervised by you. Does that sound fair to you?
Yes.
And finally, is there any reason why Autumn cannot work?
Other than the drugs, no.
She's not blind or in a wheelchair or anything.
No.
Does she have any other children besides Kason and Terry?
No, legally, no. She gave up a daughter to, just gave the child up. It was adopted at birth.
So are you asking the court to set what's called minimum wage child support on Autumn?
Yes.
Now, as far as Mr. Latham, would you agree with me right now? He's in federal prison and can't make minimum wage.
Yes.
Are you asking the court to set minimum wage child support on him for the first month, 90 days after he's released, which is the same order we've got previously?
Yes.
Is all of that in the children's best interest?
Yes.
Ask the witness.
Thank you. Ms. Rush, you may call your next witness.
Department calls Danelle Columbus. Would you agree with me that since the previous order naming the department managing conservator in a final order in suit affecting the parent-child relationship that was signed on September the 9th, 2021, there have been material and substantial changes?
Yes.
Specifically in this case, has Mr. Terry Greenroy completed licensing and has already negotiated for the permanency care assistance subsidy?
Yes.
So if the court goes along with us today, she can sign an order today and it won't interfere with him getting the subsidy. Is that right?
That's correct.
Would you agree with me that raising two extremely active grandkids is going to require some additional money help?
Yes.
Bunnies are not cheap, are they?
From what I found out, no.
Do you agree with Mr. Greenroy that the appointment of Autumn and Joe Don Latham as managing conservators would not be in the children's best interest because it would significantly impair their physical and emotional well-being based upon the fact that Autumn has had basically nothing to do with them for 3 years, is apparently still doing drugs, and Mr. Latham's still in federal prison?
Yes.
Do you have any concerns about Terry being named managing conservator and the department being dismissed?
No.
If you did, would you have picked the children up long ago?
Yes.
So how many times have you actually met with Autumn?
Once.
She hated you, didn't she?
Yes.
Okay. You heard Terry testify that the only right he wants the parents to have is the right to receive information about the kiddos. Do you agree that's really the only right they deserve to have?
Yes.
And that the other rights might interfere with the children's well-being in that, as Terry testified, Autumn coming to pick up the kids in an emergency could be worse than any emergency.
I would agree with that.
Do you agree that the visitation schedule I outlined with Terry is a fair and protective way for Terry to allow the parents to have visitation at some point?
Yes.
Do you also agree with the child support that I went over with Terry?
Yes.
So, today, are you asking the court to find that there has been a material and substantial change since the September 9th, 2021 order that Terry be named managing conservator, that Autumn Greenroy and Joe Don Latham be named possessory conservator with very limited rights, that the court dismissed the department, the court dismissed Ms. Fowler, and that the court approved the visitation, child support, and order $50 in medical support, and I think it's $50 total or $25 for each child, and 50-50 on any uninsured expenses, even though frankly, Terry's never going to see a penny.
Yes.
Is all of that in the kiddo's best interest?
Yes.
Do you have any concerns about these children at all?
No, they're great. I'm going to miss them.
Said, are you going to miss the children and Terry?
I am.
Pass the witness.
Miss Fowler.
Ms. Columbus, Mr. Greenroy's been doing this for quite some time with the kiddos, taking care of them, making sure all their needs are met. Is that right?
Yes.
Have you gotten to know Mr. Greenroy pretty well throughout your time as the caseworker on this case?
Yes.
Is there any reason to believe right now that he won't be able to continue to do those things?
No.
Is it clear that the parents are not able to do the things for the children that Mr. Greenroy is able to do right now?
Yes.
And based on the 3 years that you've been involved, there's never been a time they've been able to take care of the children like Mr. Greenroy does. Is that fair?
Yes.
Based on what you know about the parents, is there any reason to believe that that will change anytime in the near future?
No.
Nothing further, Judge.
Thank you. Anything further from this witness, Ms. Rush?
No, ma'am. Department rests.
Thank you. Ms. Fowler, do you have any witnesses at this time?
I have no witnesses, Your Honor.
Do you rest?
I do rest.
Do you have a recommendation as both attorney and guardian ad litem?
Yes, Your Honor. I would ask that you appoint Mr. Greenroy as the permanent managing conservator of these two children and sign the order that's been presented, save and accept, limiting the rights under 8.3 on page 6 of the final order. And I believe all of that to be in the best interest of the children.
Your Honor, if I may, I'd like to inform Ms. Fowler, I had not forwarded this to the judge. I don't do that until after the hearing. And there was a mistake saying that Mr. Greenroy was not licensed in my previous order, but I'm taking it out.
Thank you. At this time, the court is going to make the following findings. The court is going to find that Autumn Greenroy signed a waiver to the petition of modification in February of 2023. She has not appeared, and so has solely defaulted in this matter. The court will note that the father, Joe Don Latham, was served with the petition to modify in this case in August of 2022, and he has not appeared or filed, and so he has defaulted in this matter. The court is going to find that there has been a material and substantial change to the parties of the original final order, which was entered in September of 2021, and so the court will approve the modification. The court will name Terry Greenroy as the permanent managing conservator. Autumn Greenroy will be named a possessory conservator of both of the children. Joe Don Latham will be named a possessory conservator of the children. The court does find that the parental presumptions have already been rebutted from the September 9th of 2021 hearing. The court does find specifically to name Autumn Greenroy or Joe Don Latham as a managing conservator would significantly impair the physical or emotional well-being of both of the children. The court is going to find that Terry Greenroy has successfully completed the requirements of the Permanency Care Assistance Program and has met all of the requirements under 263-408 of the Family Code and 263-409 of the Family Code. The court is going to order that Autumn Greenroy pay child support a minimum wage of $280 a month. That is to begin on June 1st. The court is going to order that Mr. Latham provide monthly in-kind provide child support in the amount of $280, and that will begin 90 days after his release from incarceration. The court regarding visitation is going to agree to allow the parties any visitation at any times agreed to between the parties. Ms. Greenroy will not have any visitation until she provides a negative hair follicle, and that must be negative of any illegal substances or a drug that she does not have a current prescription for. She must provide that hair follicle to Mr. Greenroy, and that will be at her own expense. If she also, with both parents. There'll be no access to the children, face-to-face access to the children until that is approved by the children's therapist. In addition, Mr. Latham shall continue his twice a monthly phone calls. They shall be supervised. And upon his release, he may have face-to-face contact with the children at any times agreed to between Mr. Greenroy and Mr. Latham. The court is going to order that Mr. Greenroy has the ability to test either parent over the counter. If the parent refuses to test or it comes back positive for an illegal substance or something that they do not have a current prescription for, then there'll be no face-to-face access to the children until that parent provides Mr. Greenroy with a hair follicle at the parent's expense. Is there anything else that needs to be? The court will dismiss Ms. Fowler as both the attorney and guardian ad litem upon the entry of an order. The court will dismiss the Department of Family and Protective Services and to engage upon the entry of an order. Is there anything else that needs to be addressed at this time, Ms. Rush?
Yes, ma'am. Are you going to limit the rights of the parents?
I am going to limit both parents under 153.073. The only right that they will have is the right to receive information from Mr. Greenroy of the child concerning the health, education, or welfare of the children.
Nothing further.
Ms. Fowler, is there anything I need to add or clarify at this time?
No, ma'am.
And I'm sorry, Mr. Greenroy, I do have one other question for you. This is the only time I can do this. Would you like me to order that Kaysen or Terry cannot be involved in raising rabbits from this point forward?
That would be a blessing, Your Honor.
And does that include any other animals, pigs, cows, steers, lambs?
Could you include elephants, zebras, and giraffes?
Yes, sir. The court will make that addendum as well. Thank you, Mr. Greenroy. I know it's been a long, hard thing, but thank you for being the stable thing for your grandchildren. I know they're keeping you young, and I certainly appreciate you wanting to parent at this stage in your life. And I have seen your schedule, and it just makes me tired just reading it, much less actually seeing someone participate in it. And you are doing a phenomenal job with your children, with your grandchildren. Best of luck to you, sir.
I appreciate it, Your Honor. And I would like to say, in behalf of Danielle Columbus and Christine Andinone and the supervisor, Nora, these three people have been exceptionally good and covered everything I've needed on a daily basis, or answered any questions I had, or if I need any help, they were the first ones to jump out there and do what needed to be done. So I commend.
You know, they're legally no longer involved, but all three of those women are your friends, and you can still contact them at any given time.
Yeah, I think they should get us a snow cone or something once in a while.
Well, thank you for your, you won the jackpot of workers in this case. And so I appreciate your saying that out loud, because those women work hard each and every day. And I certainly appreciate someone that can see that. And best of luck to everyone. Thank you. You may proceed, Ms. Rush.
May it please the court, state your name and how you're currently employed.
April Moncia, permanency case manager for To Engage.
Have you reviewed the records left by the previous caseworker who is no longer with To Engage?
Yes.
Okay. Do you have an approximate amount of time you've had this case?
Since the end of January.
And have you ever actually physically met either Ms. Boner or Mr. Moore?
No.
Do your records from the previous caseworker indicate that he met personally Ms. Boner one time, but never actually met Mr. Moore?
Yes.
Do your records also indicate, as well as the court records, that the only time either parent has appeared at a hearing since the removal was when both parents appeared at the adversary via Zoom?
Yes.
So they've never visited this child, have they?
No, they never visit.
Have you had some text or email Hold on. Ms. Davis is saying she can't hear, Your Honor. You have had, however, either text or email contact with Mr. Moore. Is that correct?
Yes.
Have you had text or email contact with Ms. Boner?
No.
However, has Mr. Moore led you to believe that he and Ms. Boner are still a couple?
Yes.
Are you aware of why Ryder came into care?
Yes.
Why?
He came into care because he tested positive for methamphetamines, amphetamines, and also STD.
And the STD was syphilis, is that correct?
Correct.
And has he, through the department, gotten medical attention for the syphilis, and he's no longer having syphilis?
That is correct.
Okay. Would you agree with me that a child at birth who tests positive for methamphetamines as well as syphilis meets the definition of abuse or neglect of a child?
Yes.
And so do you agree with me that Ryder was removed under Chapter 262 for abuse or neglect of a child?
Yes.
And that the department has been temporary managing conservator of Ryder for at least 9 months?
Yes.
Has the department attempted to reunify the child with either parent?
Yes.
And does the department do that by specifically setting out a family plan of service that sets out the actions necessary for each parent to obtain the return of the child?
Yes.
And is that family plan of service court ordered?
Yes.
You said that was a reasonable effort to return the child. So let us discuss first. Well, in this case, there's been one family plan of service for both of them, right?
Correct.
And that's because they're a couple, right?
Yes.
Okay. So did either Mr. Moore or Ms. Boner attend the permanency conference that set up the family plan of service?
No.
So not only did the previous caseworker not see these parents and you not see these parents didn't even show up to do the family plan of service for their kiddo.
That's correct.
Let's talk about the court ordered services. I'm just going to call them mother and father. Is that okay with you?
Yes.
Were the mother and father both ordered to complete a substance abuse evaluation and follow all recommendations?
Yes.
Okay. Did either one of them complete a substance abuse evaluation?
No.
Would you agree with me you can't follow the recommendations if you don't do the evaluation?
Yes.
So they've not complied with that, correct?
That is correct.
They were to submit to random drug screens. How many random drug screens have they each submitted to?
1.
And they were to test negative. Did they test negative?
No.
Did they both test positive for methamphetamines?
Yes.
Okay. Would you agree with me they've not complied with that portion of the service plan?
Yes.
Now, they were not asked to take any other random drug tests because, frankly, you couldn't find them. Is that fair?
That's correct.
They will not associate with persons who use, manufacture, sell, or have criminal history. So, have they complied with that?
No.
Did Mr. Moore notify you via email that he had just gotten out of jail while this case was pending?
He notified my supervisor.
And would you agree with me that indicates some sort of criminal history?
Yes.
And she's hanging out with him, right?
Yes.
Do you know if either one of them have been arrested for family violence?
To my knowledge, I believe so, but I can't confirm whether.
So would you agree with me? We'll kind of make that one a wash since you think so, but you've not seen the paperwork?
Correct.
They were both to complete psychological and follow all recommendations. Did they do that?
No.
If you don't take the psychological, can you follow the recommendations?
No.
So would you agree not complied?
Correct.
They were both to complete a mental health evaluation. Did they, either one of them do that?
No.
Do you agree with me? Not complied?
Not complied.
And you can't follow the recommendations if you don't do the evaluation, correct?
That's correct.
Provide and maintain a safe and stable home with working utilities, allowing you and the attorney ad litem, who's also the guardian ad litem, to make announced and unannounced visits as well as photograph the home. Are you sure where they are currently living?
No.
Do you have an address that you've left a card on?
Yes.
And then reviewing the previous caseworker's records, did it indicate he was never allowed in the home?
Yes.
At one point, Ms. Boner came out of the home and talked to him, but also at one point, someone else who said she was related to Ms. Boner came out and talked to him, correct?
Yes, that's correct.
But would you agree with me, since no one's been allowed in the home to take pictures and you've not been able to verify it has working utilities, nor have you been able to verify they're actually living there, that they have not complied with that portion of the service plan?
They have not complied.
They will obtain and maintain stable employment, providing proof of income. Have they done that?
No.
Do you have any idea if or where they may be working?
No.
The next one is the refraining from criminal activity. You've already discussed that, correct?
Correct.
They will notify to engage within 72 hours of any major life changes, such as change of address, change of employment, relationship, that sort of thing. Did they do any of that?
No.
Were referrals made or attempted to be made for Ms. Boner and Mr. Moore to do their services?
Yes.
They were referred for individual counseling. Did they do that?
No.
Not complied. They were referred to focus mothers and fathers, which I believe is an online class.
Yes.
Did they do that?
No.
Their psychological was with complete psychological, which is also online, correct?
No, I believe he was referred in person.
Okay. May the record currently reflect that the child is now present?
Yes.
No, the judge does that.
Oh.
The court will agree with Ms. Mancia and have the record to reflect that the child is currently present as well.
And April, just to make sure that the one that's waving at us, that's Ryder, correct?
That is Ryder.
Hi, Ryder. Oh, look at him smile. He's a cutie, isn't he?
Yes, he is.
Would you agree with me, based upon everything that you've testified to, the parents have not complied with the court-ordered service plan?
Yes.
You said that neither parent has visited Ryder at all. Is that correct?
That is correct.
Is part of it because they only took that one drug test?
Yes.
Okay. But have they called you since then saying, we want to see the kid, I need to take my drug test, when can we visit?
I did receive an email
When?
back in March, late March.
And asking for visitation?
Just requesting in general, what do they need to do to get visitation?
And did you tell them they need to take a drug test?
Yes, my supervisor replied all to every party.
And did they ever set up a drug test?
No.
Did they ever call you asking for call you personally asking for visitation?
No.
I believe you got an email earlier this month. Is that correct?
Yes.
From Mr. Moore?
Yes, in April 6th, I believe.
And in the April 6th email, did Mr. Moore tell you that he, on April the 6th, which is more than 9 months after this child was removed, did the email tell you that he and Ms. Boner are now ready to start working their services?
Yes.
You're going to be too late, too little.
Correct.
Okay. So do you agree that neither parent has regularly visited or maintained significant contact with Ryder?
That's correct.
Considering Mr. Moore, we know has been arrested, we know that they have not done anything to deal with their drug addiction. Is that fair?
That is fair to say.
That they have tested positive, but we're not sure where they're living. We don't know if they have a job. We don't know who they're living with, that neither parent has demonstrated an ability to provide Ryder with a safe environment.
Yes, that's correct.
So the current plan, oh, I'm so sorry, is adoption by the Davises of Ryder. Is that correct?
That is correct.
And Mr. and Mrs. Davis are the, is it maternal or paternal?
Paternal.
Paternal great grandparents for Ryder, right?
That is correct.
Now, looking at them with Ryder still waving at us in the Zoom, it appears they look awfully freaking young to be great grandparents.
Yes.
Are they in amazingly good shape for great grandparents?
Yes.
Now, they live in a town outside of Region 2, but not going into the name of the town, okay? Is that correct?
That's correct.
Have you visited Ryder in their home?
Yes, on March 15th.
And prior to that, the previous caseworker had visited, correct?
Correct.
And you're seeing live action of their interaction with Ryder right now, aren't you?
Yes.
Does Ryder treat them as a child would treat a parent?
Yes.
And do they treat him the way they would treat their son, not their great-grandson?
Yes.
So based upon that, does it look like to you, if Ryder could talk, but frankly he can't because he's under a year old, right? That he would say, leave me with my granny and granddaddy, or what? You know what? Well, he doesn't. Does he call them anything?
He says mama and papa.
So if he could tell you and you could ask him, would he say, leave me with mama and papa?
Yes.
Because Ryder was born with methamphetamine in his system, as well as the diagnosis of syphilis, is there a possibility he may have emotional or physical needs in the future that an average child would not need?
Yes.
Have the Davises been made aware of that?
Yes.
And they understand what they may have to do, whether it's educational, medical, that sort of thing in the future because of his exposure in utero?
Yes.
And in fact, are you working on getting him set up with, among other things, a fetal alcohol syndrome test to see if there's any issue with that?
Yes.
But based upon another case, have we discovered there may be a 2 to 3 year wait in getting a test actually done?
Yes.
Has either Mr. Moore or Ms. Boner demonstrated any ability to care for an average child now or in the future?
They have not.
Have they demonstrated any ability or frankly any interest in caring for a child that may have special needs now or in the future?
No.
Would you agree with me, since they have not seen this child for over 9 months, that you cannot access their hands-on parental ability? Is that fair?
That is fair.
However, based upon the fact that they've not kept in touch, they've not wanted visits, they have tested positive, at least one of them has been arrested, and you don't know whether they're living or working, that the generic parenting abilities you have seen are bad.
Correct.
Now we are actually seeing parenting abilities live right now with the Davises. Okay, now we're seeing a ceiling. Oh, there they are again. So do you agree with me? It looks like they are doing good parenting abilities.
Yes.
And it looks like he's teething, which is bad, right?
Yes.
Have you seen anything with the Davises that give you concern about their parenting abilities of Ryder?
No.
If you had, would you have picked him up and put him in foster care?
Yes.
Has either Miss Boner or Mr. Moore demonstrated any stability in their home life?
No.
Does it look like the department's plan for adoption by the Davises is a stable option?
Yes.
If anything should happen and the Davises could not adopt, is there any reason to believe Ryder cannot be adopted by a loving, caring family?
That's correct.
He could be, right?
Yeah, he could be.
Other than using drugs, any excuses for Ms. Boner's and Mr. Moore's actions and inactions in this case?
Not to my knowledge.
Do you believe it's in the best interest of Ryder that the father's Mitchell Moore's rights be terminated?
Yes.
Do you believe it's in the best interest of Ryder that Rachel Boner's rights be terminated?
Yes.
Are you asking that the department be named permanent managing conservator?
Yes.
Are you also asking that this court set this for a permanency hearing after final order at a time period as required by the Texas Family Code?
Yes.
Is there anything about the parents, the placement, or Ryder that this court needs to know before I pass you?
Ryder's doing very well. He is a very small child. He's in the 2% tile for children his age group. He's kind of cute. I mean, to see him in a walker, it looks like a little baby doll. He's active. He's crawling. Well bonded, both grandparents to Ryder, vice versa. Doing a good job. He's thriving.
Thank you. Pass the witness.
Miss Barron.
Thank you, Your Honor. April, despite Ryder being in the 2nd percentile, is he still meeting all of his milestones in the Davis home?
Yes.
And you said he is crawling. Is he also starting to attempt to take steps, pulling up, things like that?
Yes.
And are those age-appropriate behaviors?
Yes.
You mentioned getting some fetal alcohol syndrome testing. Why is it that we're looking into testing for fetal alcohol syndrome?
I'm not a doctor or medical expert, but based upon my knowledge and work experience dealing with children that are diagnosed with fetal alcohol syndrome, Ryder does displace the facial features of children that are diagnosed with fetal alcohol syndrome.
And are you aware that someone who is a doctor that he demonstrates some of the facial features that indicate fetal alcohol syndrome?
You broke up there, Jordan. Can you repeat that?
I'm sorry. Are you aware that Ryder has seen a doctor who has agreed with you that he demonstrates some of the facial features of fetal alcohol syndrome?
Not a doctor, but ECI specialist. Screener.
Was that also brought up by an ophthalmologist that Ryder saw?
Yes.
The Davises are getting licensed, isn't that right?
That is correct.
Do you know what point of the licensing process they're in at this time?
They are they lack maybe a couple of classes left to becoming fully licensed.
I'll pass witness.
Anything further, Miss Rush?
No, ma'am. Department rests.
Thank you. Miss Barron, do you have any witnesses?
No, Your Honor.
Do you rest?
Yes, I rest and close.
Thank you. Do you have a recommendation?
It's my recommendation that this court find that the evidence is sufficient to terminate the parental rights of the parents, Ms. Bonner and Mr. Moore. Sorry. Name the department the permanent managing conservator of the child, for Ryder to remain in his current placement so that we can work towards permanency in the Davis home.
Thank you. And Mr. and Mrs. Davis, I know that you can at least see us, and are you able to unmute? It's in the lower left-hand corner.
I found it.
Thank you.
Our Wi-Fi wasn't working, so we're on a cell phone.
I was just wanting to know if there's anything you would like me to know about Ryder or the current case that's not already been discussed.
Other than the fact that he is an absolute awesome baby, despite his beginning, we really have nothing. Y'all have said pretty much all you need to say about our family on the other side. It's a sad day to know that my own nephew's rights are being terminated possibly, but it's a happy day to know that he's with us and he's going to be well taken care of and well loved, very well loved.
Yes.
Thank you. Anything? He certainly is a cutie pie. The court will note he is an official cutie pie. Thank you, Ms. Davis.
Thank you.
Sir.
If there's not anything else that needs to come in front of the court at this time, the court is going to make the following findings. The court is going to find in regards to Rachel Boner, court will show
Bubby.
the court will show that the department has shown by clear and convincing evidence that Rachel Boner has engaged in conduct or knowingly placed the child with persons who engaged in conduct which endangers the physical or emotional well-being of the child. The court will find that Ms. Boner has constructively abandoned the child who has been in the permanent or temporary managing conservator of the Department of Family and Protective Services for not less than 6 months, and the department has made reasonable efforts to return the child to the parent. The parent has not regularly visited or maintained significant contact with the child, and the parent has demonstrated an inability to provide the child with a safe environment. Likewise, the court will find that Ms. Boner has failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the department for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of the child. The court will find that Ms. Boner has used a controlled substance as defined by Chapter 481 of the Health and Safety Code in a manner that endangered the safety of the child, the health or safety of the child. The mother has failed to complete a court-ordered substance abuse treatment program, and Ms. Boner has been the cause of the child being born addicted to alcohol or a controlled substance other than a controlled substance legally obtained by prescription. The court therefore will terminate the parent-child relationship between Rachel Boner and the child under Chapter 161.001 of the Family Code, Section 161.001B1E as in elephant, N as in Nancy, O as in oatmeal, P as in Paul, and R as in rabbit. The court does find that the termination of this parent-child relationship between the mother and the son is in the child's best interest. The court will find that Ms. Boner has failed to show by she was unable to comply with the specific provisions of the court order, or that she made a good faith effort to comply with the court order, and the failure to comply with the court order was not attributable to any fault of the parent. In regards to the father, Mitchell Moore, the court will find that the department has shown by clear and convincing evidence that Mr. Moore has engaged in conduct or knowingly placed the child with persons who engaged in conduct which endangered the physical or emotional well-being of the child. Mr. Moore has constructively abandoned the child who has been in the permanent or temporary managing conservatorship of the Department of Family and Protective Services for not less than 6 months, and the department has made reasonable efforts to return the child to the parent. Mr. Moore has failed to comply with the provisions of the court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the department for not less than 9 months. Mr. Moore has used a controlled substance as defined by Chapter 481 of the Health and Safety Code in a manner that endangered the health or safety of the child and has failed to complete a court-ordered substance abuse treatment program. Therefore, this court will terminate the parent-child relationship between Mitchell Moore and the child based under Texas Family Code 161.001B1E as in elephant, N as in Nancy, O as in oatmeal, and P as in Paul. Likewise, the court will find that Mr. Moore has not shown by a preponderance of the evidence that he was unable to comply with the specific provisions of the court order, and that he has made a good faith effort to comply with the court order, and his failure to comply with the court order was not attributable to any fault of the parent. The court does find under Chapter 153 that all of the parental presumptions contained in that chapter have been successfully rebutted. The court will specifically note it has considered Chapter 153.044 regarding the history of domestic violence and abuse. The court will note to name a parent as a conservator of the child would significantly impair the physical or emotional well-being of the child. The court will note that the termination of the parent-child relationship between both parents is not based under any of the Texas Family Code 262.116 factors. It is not based on the fact that the child may have been homeschooled, may have come from an economically disadvantaged background, may have been behind on immunizations, engaged in independent activities, or received medical marijuana. Nor is it based on the fact that a parent sought out a second medical opinion or was charged with a nonviolent misdemeanor, or that a parent and child tested positive for marijuana alone in a manner that significantly impaired the physical or emotional well-being of the child. Or the court will name the Department of Family and Protective Services as the permanent managing conservator of the child. The court will specifically note for the record that both of the parents appeared via Zoom, in which they received notice of that hearing via their email, and that was held on July the 15th of 2022. Neither parent appeared for the status hearing, which was held on August the 18th of 2022, or the initial permanency hearing set and held on December the 15th of 2023. At no time during this case did either parent appear in opposition to the department, nor did at any time did either parent request a court-appointed attorney or complete the necessary steps for a court-appointed attorney. Neither parent has updated or maintained the updated information regarding their contact information, email information that was court ordered at that adversary hearing on July the 15th of 2022. The court will continue the placement of the child with Bobby and Frances Davis. The court will continue Mr. and Mrs. Davis as both the medical and education consenter for the child. The court does find that this placement is the least restrictive for the child, and the department has made reasonable efforts to achieve the permanency goal, which is related adoption. The court will continue the child's current service plan that is currently in place. Is there anything additional that needs to be addressed at this time, Ms. Rush?
No, ma'am.
Anything from you, Ms. Barron, that I need to address?
No, Your Honor.
Then we will go off of the record. I would like to say thank you, Ms. Davis, and you have my sympathy for, you are much more computer savvy and technical savvy than I am. So I applaud your efforts to stay with us and to join us today. And thank you for caring for that adorable baby, and best of luck to you. And we thank you, Mr. Chris, for court reporting for us today. And just a reminder to anybody, it is illegal to record or post any of the court proceedings in this matter. Contents of its file. And we will go off the record. And I will ask if LG is able to hear us at this time. Ma'am?
Yes.
Who are you?
I'm Mackenzie Connor.
Thank you. And Ms. Connor, are you by yourself?
Yes.
Okay, thank you. The court will note that LG is the mother, Mackenzie Connor. The court will take judicial notice of the contents of its file. And if the court can have announcements.
Ursula Rush and Danelle Columbus for the department ready.
Amy Smith, attorney ad litem for the child. He's not present. I'm ready. And I'll note that the foster mother, Jenny Rowell, is also present.
Thank you. You may proceed, Ms. Rush.
Thank you. Department calls Mackenzie Connor.
Thank you. You may proceed.
Are you Mackenzie Connor, the mother of Johnny Black? Ma'am, are you there?
That the person, Ms. Connor, who was using LGL55DL, has not responded I'm sorry, Ms. Rush, if you'll continue, if she is able to rejoin us. I am getting a 981 phone number that would like to join us.
Your Honor, that may be Mr. Underwood.
Yes, I'm Mackenzie Connor. I was on the video, but my data I don't have enough of it it kept exiting out of it.
Okay, so you are now appearing under 981. Are you still by yourself, ma'am?
Yes, ma'am.
And as I understand it, you are unable at this time to appear by video, but you are appearing by phone, correct? Are you there, ma'am?
Ms. Connor?
Yes, I'm here.
Did you hear my last question?
Yeah, I was trying to answer. You couldn't hear me though.
Correct.
I couldn't do it by video because I didn't have enough data on my phone, so that's why I called in.
Okay. And do you have a current address for Kenneth Sean Underwood?
I don't at this moment, but I can get one though.
Okay. You've been asked multiple times to provide an address so that we can have him served. When can you get us an address?
I could call back later today, or every time I get one, he moves.
Okay. He is aware of the hearing today. Is that correct?
Yes, I told him.
And he was.
I told mutual friends, and they told him, but.
Okay. And he was given the Zoom link, correct?
Yes. Danielle said she emailed it to him.
Okay. So can you get Danelle his address by 2 o'clock this afternoon?
I will definitely try, yes.
Okay. What time can you definitely get her the address by?
I'll get it today by 2.
Okay. Do you know if Mr. Underwood has a job?
Not that I'm aware of. I'm not sure.
Do you know if he has any relative which he is in contact with on a regular basis?
Maybe his brother.
Does his brother live in Texas?
Yes, it's far, but I'm not sure what town, but.
Do you have an address for his brother?
No, but I can get that too. I can message his brother and ask him.
The email for Mr. Underwood, is it a Gmail address?
Yes, ma'am.
And does it include the numbers 558?
Yes, ma'am.
Okay. Are you aware if that email is valid and works for him?
Yeah. That was the last one he had.
Okay. Danelle has asked you for your current address. Is that true?
Yes, I could still send it to her. I'm just staying with friends right now until I can get me a more permanent place.
And didn't you tell her when she asked that you would have to check with your friends before you gave her the address?
Yeah, I did check with them. I just forgot to message her.
So can you by 2 o'clock today give Danelle your current residence address?
Yeah. Yes, ma'am. I'll text her as soon as I hang up with y'all.
Okay. And is it in Montague County?
Yes.
Did you participate in the formation of your family service plan?
Yes. Me, Danielle, my mom, and Mark were all in a room. Yeah.
Mark who?
Mark Hansen.
Okay. This would have been a Zoom meeting in which the service plan was formed.
Oh no, I didn't do that one.
And why did you not do that?
I didn't even know how to do Zoom. I've never used this before. Okay. And I just ended up missing it.
Per court order, are you opening the e-files once they come through?
Yes, and I sign them if they need to be signed, and they had me do the.
Ma'am, you got to let me ask questions and you answer, okay? Or we'll be here all day. So you are opening the e-files, correct?
Yes.
So you did get a copy of the April 11th filing of your family service plan. Is that correct?
Yes.
Okay. And you have not signed it, but you're going to make arrangements with Ms. Columbus to sign it. Is that correct?
Yes, ma'am.
Okay. And you understand we will be asking that that be made a order of the court today?
Yes, ma'am. I'll do that as soon as I hang up.
Well, we will be asking that the service plan be made an order of the court and you be required to complete the services on that plan. Do you understand that?
Do you know what services?
The service on the plan that you said you opened that was filed April the 11th.
I mean, yeah, I'll do whatever the court tells me to.
Okay. And you understand if you have any questions, you need to go to Danelle.
Yes, ma'am.
Also, we did receive a acknowledgement of paternity signed by you and Mr. Underwood. That is correct, right?
Yes.
And you understand that today we are asking the court to specifically name Mr. Underwood the legal father of Johnny.
Yes, ma'am.
And you're cool with that?
Yes, ma'am.
Okay. We are having this hearing by Zoom, which is unusual for a status hearing. But are you aware that the next hearing is August 17th, excuse me, at 9:30 a.m. and it will be live in the Montague County Courthouse, 97th Judicial District, unless you get a Zoom link in advance?
Yes, ma'am. I will be there.
And the hearing after that is December the 6th, 2023 at 9:30 a.m. live at the Montague County Courthouse, 97th Judicial District, unless it turns out that she has to have it by Zoom, like because we have a snowstorm.
Yes, ma'am.
Okay, pass the witness.
Ma'am, do you understand that you have to give notice regarding your visitation in advance? You plan to attend your visitation?
Yes. Yeah, I got a text. Yes.
And so do you understand exactly what you need to do and when you need to do that?
Yes. Danielle sent me all of that yesterday.
Okay. And you understand that when you cancel last minute, it is an issue for little Johnny and foster parents and CPS and everyone else. So it's important that you follow that. Okay. Thank you. I'll pass the witness.
Connor, let me ask you a few questions. Is there anything that you think would be beneficial to you that is not being offered by the department?
I mean, no, y'all have been great. And it's just me that kept missing, which I won't do anymore.
And you understand that your family service plan, which is on that April 11th, deals with counseling, parenting, substance abuse assessment, random drug screens, a psychological evaluation, employment, housing, to keep everyone updated of your email, relationship, employment status, announced and unannounced home visits, child support, and to sign releases and to open emails. Do you understand that? Ms. Connor, do you understand that?
Yes, ma'am.
Is there any of those things that you're like, heck no, I'm not going to do it. You can't make me, or I should not have to do that service?
I mean, no, I don't disagree with none of it.
Okay. And at this time, are you still in agreement with the child remaining in care while you work your services?
Well, my mom is supposed to go before Judge Lewis, I think. He might be placed with my mom until I get everything done.
Your Honor, may I inform the court there is no Judge Lewis in Montague County?
Ms. Connor, are you by yourself or are you speaking with someone else?
No, it's just me.
Okay. And you understand that you've agreed that the child is in foster care and will remain in foster care. The placement may change while you work these services. Do you understand that, ma'am? Ma'am?
Yes, I said yes. I didn't know if you heard me.
Okay, I'm sorry. Your connection has been a little bit sketchy. Do you have
my phone's...
Do you have any questions? Do you have any questions regarding your family service plan?
No.
Thank you. Ms. Rush, anything further?
Department calls Danelle. Did Your Honor about March 31st, 2023 file a status report to the court?
I did.
one of the changes since then is we have discovered that there was an AOP signed by Mr. Underwood and Ms. Connor asking that he be named the legal father. Is that correct?
Yes.
And you filed a family service plan for both him as an alleged father and one for Ms. Connor as the mother. Is that correct?
Yes.
Is it your understanding that Mr. Underwood has not been served because we've not been able to get an address from Ms. Connor?
Yes.
And we've not been able to find him at the only address we had.
That is correct.
And his service did come back from the constable unserved. Is that correct?
Yes.
So will you notify me as soon as Ms. Connor gives you an address today?
Yes.
If we are unable to get him served at that address, is it your understanding we'll be asking the court to allow us to serve him via substitute at his email address?
Yes.
Have you had any contact with Mr. Underwood?
No.
However, was it your understanding from Ms. Connor that he was having phone problems and would probably not be logging on today?
She said that he would be on today.
Didn't you get a notice afterwards that there might be a problem?
I just asked if the number I had was valid, and she said she didn't know if it was, if he had service right now.
Okay. So you understand we cannot ask that the court place Mr. Underwood under order since he's not been served?
Correct.
However, will you be doing a new family plan of service set out to address what you believe are the issues with Mr. Underwood since he will be adjudicated the father as opposed to the issues of an alleged father?
Yes.
I understand that you have gotten a home study back on the maternal grandmother, but it has not been staffed yet. Is that correct?
Yes.
Will it be staffed no later than next week?
Yes.
It's just a matter of getting everybody in the same room.
Yes.
And once it has been staffed, will you be filing the home study with the recommendation?
Yes.
And it's your understanding, I assume that I forwarded the home study to everyone.
Okay. Yes.
Okay. Now, regarding visitation, how many visits have you attempted to have with the mother?
6.
How many has she shown up for?
1.
How many have you attempted to have with the grandmother?
1.
And how many did she show up for at that time?
0.
Did she attempt to come at a different time?
Yes.
Did you explain to the grandmother that as a grandmother, she has limited visitation and she missed her visit?
Yes.
Did she tell you why? Did the grandmother tell you why she missed her visit?
The grandmother has not spoken to me about the visit. She did, Mackenzie did. They were together. And she said that they were given the wrong address.
Okay. And where is the visit scheduled?
At the 2 Engage office in Wichita Falls.
And that's known as Big Blue, is that right?
Yes.
And for those of you who are not familiar with Wichita Falls, Big Blue can be seen from the highway as you are coming into Wichita Falls because it's a big blue building.
Yes, it is.
The other visits that Miss Connor did not make, did she give you reasons?
Yes.
And what were those reasons?
She didn't have a ride. She hurt her back. Those are the 2 main ones.
Okay. Are you asking, though you've discussed with Miss Connor, are you asking at this time that the court order that Miss Connor must appear at the 2 Engage office for the visit 1 hour in advance of the visit, or the visit will be canceled?
Yes.
And is that hour necessary to arrange transportation to get Johnny to the visit?
Yes.
Before, have you gotten him to the visit and basically wasted a couple of hours because she didn't show?
Yes.
Are you asking the court to make the family plan of service that was filed unsigned on or about April the 11th, 2023 orders of this court?
Yes.
Are you asking the court to find that the department has exercised due diligence in getting Mr. Underwood served? And we will continue to try to get him served until and unless we have to serve him by alternate means.
Yes.
In addition, okay. Would you agree with me that since you don't even really know where Mr. Underwood is, he's not contacted you, he has not shown any interest whatsoever in Johnny, and you're aware of his extensive criminal history, is that correct?
Yes.
And were you present at the adversary when I believe Ms. Connor testified that he might have thought there was a warrant for his arrest and that's why he was dodging service?
Yes.
You agree that placement with him would constitute a continuing danger to Johnny?
Yes.
Now, you did ask Ms. Connor where she was living at some point. Is that correct?
Yes.
Do you agree with her? She told you she'd have to talk to the people she was living with and couldn't give you the address at that time.
Yes.
Have you been told that she has been charged, though not indicted, I don't believe yet, for endangering a child?
Yes.
You're not aware of what her bond conditions may or may not be. Is that correct?
That is true.
However, do you believe the fact that you don't know where she's living, she's made one visit since this case has been ongoing. She didn't attend the Zoom hearing to set up her service plan. You don't know where she's living. She's not addressed her drug use, that placing Johnny with her would constitute a continuing danger.
Yes.
Are you asking the court? Well, you were present when I told Ms. Connor the dates of the next 2 hearings. Is that correct?
Yes.
Are you asking the court to make sure that she understands, that Ms. Connor understands that notice has been given in open court?
Yes.
How's Johnny doing?
He's doing well.
Are there any problems that have arisen because of the complications with his birth?
He is on special formula. He was underweight, so he's on a high caloric formula. He has to be fed a special way that cooks had to explain, but the caregivers actually already knew how to do. He has colic right now, so when he hits the 3-month mark, if he hasn't kind of outgrown that, they're hoping he will. They will change his formula to a sensitive formula and medication if necessary.
Obviously, he's too young for cans, etc. Do you know if he has any follow-up visits at Cook scheduled?
No.
Okay. Anything else about Johnny or the parents that this court needs to know before I pass the witness?
No.
Pass the witness.
Ms. Connor, do you have any questions for Ms. Columbus?
Not at this moment.
Thank you. Ms. Smith?
Thank you. Danelle, little Johnny has gained some weight since he's been placed with the Rouse, correct?
Yes.
And so given all his issues, he seems to be doing well.
Yes.
Do you agree?
Yes.
And I believe there actually is a follow-up hearing at Cook's, but it's not for quite some time. So just FYI. Is anything else that is going on with the baby that you think the court needs to know?
I think he's doing wonderful with the current placement. They were very nurturing, loving. He loves to be held constantly.
There's some other children in this house that are obviously very bonded with Johnny already, correct?
Yes.
Thank you. I'll pass the witness.
Anything further, Ms. Rush?
No, ma'am. Department rests.
Ms. Connor, do you have any witnesses you'd like me to consider at this time?
No, ma'am.
Is there anything else you would like to tell me that has not already been addressed?
No, ma'am.
Ms. Smith, any witnesses?
No, Your Honor.
Thank you. Do you have a recommendation as the attorney ad litem?
Just that the placement be approved and the family plans of service be made in order of the court.
Thank you. Ms. Paschal, do you have anything you'd like me to know about the situation as guardian ad litem?
No, Your Honor. I visited with the placement. I saw the baby. The baby was resting. She said he was doing well.
Thank you. And thank you for your work on this case. Miss Jenny, if you can unmute.
Yes, ma'am.
Is there anything you would like me to know about the baby that hasn't been discussed?
The only thing was that Cook's appointment. They literally just called me about that, and it's not till like October. That was like the first time they could get him in. That was the follow-up. So it's a ways away.
And how is he doing with the colic?
He's doing good. I would say it's minor. I would probably say every other evening we're pretty fussy and unconsolable, but nothing that like we can't manage.
And is there anything you need for Johnny that's not already being provided by the department or to engage?
No.
And thank you very much for taking such good care of little Johnny. Thank you.
Of course. Thank you.
Is there anything else that needs to come in front of the court at this time?
No, ma'am.
The court is going to make the following findings. The court is going to find that there's still a continuing danger to the physical or emotional well-being of the child if he were returned to a parent today. The court is going to find that the department has made due diligence in trying to serve with citation and notice of this proceeding to the father, Kenneth Sean Underwood. The court will legally establish Mr. Underwood as the legal father of the child based on an unrescinded acknowledgement of paternity that was signed by both Mr. Underwood and Ms. Connor at the hospital, and as testified today and at the adversary hearing by Ms. Connor. The court will vacate any orders requesting ordering paternity testing that this court may have entered prior to this proceeding. The court is going to order Ms. Connor to provide both not only her address, but an address for Mr. Underwood to Ms. Columbus by 2 p.m. today. The court is going to continue the temporary managing conservatorship of the department, as well as the possessory conservatorship of Ms. Connor. The court is going to order the department to staff the maternal grandmother's home study, and that shall be staffed and filed with a recommendation by Friday, April the 28th of 2023. The court is going to adopt and make an order of the court, the family service plan that was filed with the court on April the 11th of 2023 for Ms. Connor. The court does find that this family service plan is narrowly tailored to achieve the current permanency goal, which is family reunification. The court is going to order the Ms. Connor to appear at any visitation site 1 hour prior to any visitation in order to avoid any difficulty and disturbance on the child or the foster family, as well as the staff. In addition, the court is going to approve and continue the placement of the child with the foster family, continue the foster family as both the medical and education consenter. The court will approve the child service plan for the child, as well as the current visitation plans that are in place. The court does find that this placement is the least restrictive, and the department has made reasonable efforts to achieve the permanency goal. The court is going to waive the appearance of the child today and find that the foster mother, as well as Ms. Smith, have adequately represented, as well as Ms. Paschal, have adequately represented the child's interest.